All right, well, let's get into the serious stuff here. Going from Doomcock to Trump's second impeachment. Let's go over this. Okay, so I've been following it en diagonal, as we say. I cannot stomach it. I couldn't stomach watching it. Watching these people, feigning emotional responses to these things and trying to jerk at people's most basic primordial reactions. I can't stand it. It's politics and it's law, and when they meet, it's like the intersections of vomit and diarrhea meeting. So I've been watching it a bit. I did yesterday just a follow-up video when they said they were going to announce witnesses. And then by the time I published that video, they said they were not announcing witnesses and he was acquitted. What happened? First of all, the first question is this. Can you have a constitutional impeachment that does not respect certain constitutional protections, like due process? Can you have it, which is the argument that it's a purely political process, so it doesn't need to respect any constitutionally protected rights and protections?
That's never made sense to me. I mean, those are people arguing from power rather than arguing for what's right. Just because the politicians, that generally the court system and other people won't challenge or contest what they do, doesn't mean they're right. Otherwise, that means any political action has no constitutional limitation ever. That doesn't make any sense. Why do we have a constitution then? So the Constitution clearly applies. The argument that that because it's impeachment, magically it's exempt, never made any sense. It's not an argument they have made until this impeachment that I've ever seen. And it was sort of sad to see it be made, the perilous precedent now being set by the political class, willing to weaponize anything and everything, and don't care about restraints or restrictions, and only look to the ends, don't care about whether their means are more harmful to any ends that could be achieved in the context. So it was clear. I mean, it was all a violation. Now, they got to. Now, here's my view. My view is that every single impeachment vote should be 2/3 vote. That's what the Constitution. While the Constitution references conviction, to me, because everything's about conviction, everything should be a 2/3 vote, including what evidence is presented, what witnesses are heard, whether or not it meets jurisdictional requirements, whether or not First Amendment applies, whether or not due process applies. The Senate has chosen not to enforce that because it's inconvenient. And well, not just because it's inconvenient, it's because the Senate has almost always been controlled by the party that's in favor of the impeachment. And that's the other part of the problem. McConnell could have set a better precedent in the last impeachment by saying everything's got to be by 2/3 vote. So that's one issue there.
But sorry to stop you there. Actually, he could have said it then, but the Senate makes the rules every time. So in theory, they can make any rules they want, regardless of what precedent they've set, and regardless of whether or not they respect the very Constitution they're purportedly enforcing.
Yes, I mean, if there was any doubt that the Senate that politicians cannot be trusted to uphold the Constitution, they completely dispatched that because they had their constitutional law professor turned congressman make all those arguments. I mean, there's a guy who really put the con in con law. I mean, dear Raskin. So I mean, for him to come forward and say no constitutional restraints of any kind, that was problem one. Problem two, of course, is, so, they didn't have jurisdiction. It was a bill of attainder. It did violate the First Amendment. It did violate the Fifth Amendment. But they obviously didn't care about any of it. Their excuse was no constitutional application. The second argument, it didn't fit the definition of any crime. This time, they didn't even claim it fit the definition of any crime.
Well, in fairness, they did allude to inciting an insurrection, which in theory is criminal in nature. So at the very least, they listened to Alan Dershowitz's pleading from the first time around.
But there's a specific D.C. statute, and they didn't rely upon that statute because they knew they couldn't meet it. So there's a specific D.C. statute that's applicable for Trump, and it clearly doesn't meet the statute. Doesn't meet the First Amendment standards either that statute is limited by. So that was the second problem, of course, but they just moved past that because they decided not to have 2/3 votes on any of these issues. If we use 2/3 votes as the standards, they didn't have jurisdiction. It did violate the First Amendment, did violate the Fifth Amendment. It didn't fit the definition of a crime because they never got 2/3 votes on their favor on any of those. They just got majority votes. And so that's my interpretation of anything that's called precedential from the Senate as it relates to impeachment going forward. But the other part, of course, is, as you know, it's the old lawyer statement. When you're right on the facts, you pound the facts. When you're right on the law, you pound the law. When you're wrong on both, you pound the table. And Raskin and the House members did a lot of table pounding. They did a lot of emotional appeals. The other aspect of this was you have a judge presiding over the case who's not the constitutionally appointed officer, who's also serving as a juror, who's also potentially a witness, who's conflicted at every level possible. I saw all these liberal lawyers whining about when Republicans left the chamber, saying no juror would ever do this in a real criminal trial. Nothing about this was a real criminal trial. It was a mockery of a trial. It was an embarrassment. Any lawyer who calls that a trial should give up their law license today, because that was a disgrace. Nothing about it reflected a trial.
Two things. Someone I brought up the question asked, what of the fact that John Roberts did not preside, and someone else, King Takura, sorry, I can't remember the name now, said, it was moot because he left office. Now, one thing I didn't actually fully appreciate until people commented on my video is, every example they've been using was of someone who resigned before the trial. Those are the only two examples I think that occurred where, someone was impeached while in office, resigned before getting punished and before having a trial to avoid the punishment. This was not even that case. This was even one step above or below. I don't know which way you want to do it, but the people had voted in theory, so resolved the problem itself, but it was not as though any action, it's not as though Trump removed himself from office to avoid punishment. It was just by course, which made it extra super duper moot to try to have the trial on someone who no longer held office, but not even as a result of having resigned to avoid punishment.
And the problem is, it says any trial of it only talks about the president, not a president. And they actually had contradictory arguments. They said the president meant the president when it came to having the Chief Justice preside, but the president meant a president when it came to having a trial of someone who no longer was president. I mean, the exact same language, directly conflicting interpretations of the same document by the same group of Democratic House managers. But going past that, almost everything they introduced was all inadmissible. I mean, in a real trial, you can't, well, this goes back to the deposition analysis you did of Alex Jones. What you cannot do in a real trial is put together a bunch of your own edited clips and admit it into evidence. Especially clips that are not even, that are like double hearsay or triple hearsay, that would never be, that are prejudicial, that are immaterial to the trial. I mean, almost every evidentiary rule that you have, the Democratic House managers managed to violate. Yeah,
not just that. It kills me that I forgot to mention it in the video. Not fake. They were, what's the word? Doctored. You want to talk about doctored? Trump's face on Stallone's body is not doctored. That's humor, and if you don't get it, there's a problem. Doctored is adding a blue check mark to lend credibility to that which did not have a blue check mark, and that's not to say that the tweet would be any less impactful. But so for those of you who don't know, they were showing tweets, and it was Trump retweeting one of his aides. I forget who retweeted the tweet. They added a blue check mark to the tweet. The person is not blue check mark verified on Twitter, and they said, I've never been verified. How did my tweet before the Senate have a blue check mark when I'm not verified? And then apparently the impeachment team said, we made a mistake. That's not a mistake. That, as far as I am concerned, is falsifying evidence. So that's not a mistake. You don't accidentally doctor a tweet by adding a blue check mark to make it look like a verified account when it's not. That's not a mistake. And that blows my mind.
And that wasn't the only one. They also changed the dates on different tweets. They got caught because they let the New York Times take photos of them that showed that it was a different date than the date that they were putting up. Third, they got caught lying about what Senator Mike Lee had said, tried to falsify his testimony into the record. Unfortunately, he was a senator, so he was like, I didn't say that. Quit lying about me in a trial in which I'm a juror. So they had to correct that. They doctored some aspects of they obviously did incredible manipulation of the videos. So they presented a video that appeared to be Trump talking to people while they were rioting, which didn't happen. So, I mean, they changed the timeline, changed the sequence, changed the location. So they manipulated evidence, doctored evidence, fabricated evidence, made up evidence, manipulated evidence, all things you couldn't do in the first place, while introducing it as evidence when it was not admissible under any traditional rule of evidence, when it was immaterial, not pertinent to any relevant matter before the Senate, and often unfairly prejudicial, which is also ought to be excluded under the evidentiary rules. So you go through the key evidentiary rules, federal rules, 401, 402, 403, 404, 106, rule of completeness, rule 801 and 803. They violated them across the board. They had impermissible expert testimony. They misrepresented Professor Turley's position entirely. They used a position he had argued 30 years before when he only argued that there might be utility to holding a trial, he didn't actually make a decision in that legal brief about whether or not it is constitutional to also adjudicate guilt. He just said you could still hold a trial, there'd be public utility to it. But he had dispatched that position quite some time ago, and he made that clear in the months leading up to this. And they pretended that he still had the position until a day or two before the trial, which is totally false.
Well, first of all, leave it to Real Bambuga to get a very good, insightful joke in here. I'm surprised Twitter didn't immediately verify her account just so she'd have a blue check mark. I mean, that with the level of collusion or the cooperation between big tech and government, it's not that far off. And
last but not least, they confused Calvary the Cross with the cavalry coming in as part of the army. And so they basically defame, but again, they get away with it because they did this on the House floor. Some people had asked whether she could sue. She can't because it's on the House floor. That they made the statement. Right now, unless I win my Covington case, no politician can be sued for anything they say ever. Unless I win my Covington case before the Supreme Court or get the law changed. But they even mischaracterized what she was saying to mischaracterize what the president did. So it was the most dishonest, dishonorable presentation I'd seen in a long time that was masqueraded and made a mockery of the trial procedures that we hold dear in America.
And for those of you who don't know, they picked a tweet where they said either bring in or bring on the cavalry, which Swalwell thought said or meant to say cavalry. And in fairness, I had no idea what cavalry was. No idea. I read it. When I saw it, I didn't even see cavalry. I saw cavalry.
Well, yeah. It's a small chance Swalwell might not have known, but somebody along that way knew. Because, I mean, anybody that has any connection to the religious tradition in America knows that when it was capitalized, knows the difference of where the L and the V are. And it was extraordinary what they did, but it was just massive manipulation of evidence, for no consequence, of course. And these are a lot of the same people demanding that, say, Lynn Wood or Sidney Powell or Rudy Giuliani get disbarred just because they brought controversial claims, while they themselves did pretty much every dishonorable, sanctionable thing you could do in a trial. Democratic House managers did.
Yep. I just say the one presentation, which from a technical perspective was great, was Joe Neguse, because he put Turley in contradiction with his previous positions. When I actually paused those clips to read the excerpts, I didn't even, Neguse was sort of implying that Turley was affirming the correctness of it, where when I read it, it just sort of looked like Turley was summarizing historically what had happened.
Yes.
And in one of them where, the one statement where Turley says, no president or no man shall escape the account he owes to the laws of his country. I was like, yeah, that makes sense. I can read that one way. It doesn't mean you have a trial for impeachment once he's out of office. It means if he's out of office and a private citizen, go after him with the other laws to which he could be held to account. But they never would, because there was never anything that it would even rise to the level of remote probable cause to go after him for.
Yeah, it was. I mean, it was a sham from beginning to end. I thought the president lawyers could have presented a lot more evidence. They started off terrible. That first day presentation may have been one of the worst presentations I've ever witnessed. I don't know what. I'll give Dershowitz credit. They're asking. I mean, Dershowitz was just honest. They're like, "What do you think about this?" He's like, "I have no idea what this guy's doing." He was just like, I'm clueless. They came back better at the end. Still not spectacular in my view, because they stated they conceded certain issues that I wouldn't have conceded. They decided not to go into issues that I would have gone into, and they only leveraged that at the very end on the witness issue. They're like, okay, if you call one congressman, we call Nancy Pelosi, and we get into everything she knew. And all of a sudden, Democrats are like, hold on, never mind. Well, we don't need any witnesses. We'll pass that.
Actually, but we're on it. No, stop it before we get to the witnesses, because I have a lot of questions on that. Who was it? It wasn't Schoen. It was Castor who gave the first day presentation, right? So
Schoen came up after him, and he did okay. It's just, this was a political trial. This was like the Chicago 7 trial. This was theater. This was not a legal trial. If it was a legal trial, all this ridiculousness would not have even happened. So they seem to be unprepared for that. They got better prepared by closing, and Trump's TV team, I don't think it was the lawyers that put that together. It was Trump's TV team that put together the great scripts. They were saying, well, if we want to go down memory lane and we want to call things incitement and we want to talk about how horrendous it is to contest elections. But here's where I would have gone. On the contesting elections part, I would have played Hillary Clinton's part about contest, fight, how she kept fighting for 4 years.
Not concede. I mean, that's
not concede. That's what she said. Don't concede. And number two, I would have gone through the whole history. I would have named every famous congressman and senator since 1809 who had voiced objections to elections, and included Alexander Hamilton in 1796, how that was resolved by John Adams, same with Thomas Jefferson in 1800. Remind them that this has a long constitutional history, and this gaslighting mythology that questioning elections is somehow a moral horror is completely contrary to our constitutional history. So I would have gone into more detail on that. I would have detailed why. I would have put the president's reasonableness laid it out. Say, here's why he was concerned, and unfortunately the courts didn't provide an answer. And historically, Congress is the answer. But they decided to take a more narrow defense to placate the Lindsey Graham wing, and that mostly worked. But I mean, at the end of the day, they end up losing 2 more votes than they had when they started. So that gives you some sense of how much that really mattered. The reality was there wasn't going to be 67 votes. I was surprised that idiot Cassidy came out of hiding out of Louisiana. His political career has gone Louisiana fishing. You can look that up, what that means. His political career is finito. The rest of them were not a surprise because they're either retired, they're not up until 2026, or their last name is Mitt Romney. So and he comes from a family of losers. So he's just, he just inherited that loser trait.
I just want to say one thing about Castro, for anybody who's looking to be an attorney and to present in front of the court, never publicly announce that you're changing strategy in front of everybody.
Don't keep congratulating the other side. Golly, gee, that argument was so good. I don't even know what I'm going to do now.
I felt uncomfortable watching it because it really felt, and I'm not trying to be mean and there's no but, it felt like someone who had not prepared winging a presentation. And
yeah,
when you see
I'll put it this way, the cat lawyer did a lot better.
So you announce you're changing strategy. That's an admission that things are going badly. It's something you think to yourself, but you don't say it out loud unless you're Austin Powers thawing from cryogenically frozen. The witnesses now. So what happened? Because from what I understand, the Republicans had initially said they were not going to call witnesses. They flopped. Was it a sign of weakness? Was it calling a bluff that they knew the Dems were going to backtrack on? And because that's what ended up happening. So what happened and what did it mean beginning to end? And why did they ultimately not call witnesses?
The video presentation was so effective and the lawyers did a better job. I just wasn't overly ecstatic, but I thought the video presentation is what was really good on the president's or on Trump's closing. And because it just showed how absurd it was. And what they did is they returned the favor. They're like, okay, if you guys are going to edit stuff together, we'll edit stuff together. And our editing is going to look more impactful because you got a few guys breaking some windows and doors. We have people kicking people in the head while they're on the ground. We have people burning down buildings. We have people looting stores. We have older women crying about just losing their apartment, losing their house, losing their livelihood, and playing it next to all the statements Kamala Harris, now vice president, made, all the statements Joe Biden made. I mean, trying to pretend that the word fight is somehow imminent incitement of criminal activity was always laughable, but it was great that they just took, hey, let's use every time. And they put every single Democratic senator, all the different times, just a sampling, they had used the word fight. And of course, all of them had. So it made a point of how preposterous this position was. And because of that, the Democrats realized we need something to change the script to at least look a little better. And so they said, well, we'll call the Congresswoman who's a Republican, but who actually beat another Republican in the top 2 system in the state of Washington to win. So she's kind of a quasi-Republican who voted to impeach Trump in the House and claimed she overheard a conversation or basically it was double hearsay. It was Trump told this guy this, and this guy then told me that. And so they needed the last minute, and they thought that would salvage their day. And what was smart was Trump's people came back and said, fine, there's about 200 witnesses we would like to actually look at to depose. And on top of that, we would, and if we're only going to be allowed to call one, we'll call Nancy Pelosi and get into what really happened that day and the days leading up to it about security and safety and due process, et cetera.
Yeah, well, that's
when all of a sudden they were like, never mind. We'll just put her statement in the record and go home.
I might at that point I might have insisted him. It would have been, but I might have insisted. Let the games begin.
Oh, if it was yes. I mean, my view was to go ahead and drag this theater out, and put the election on trial, put everything that happened really on January 6th on trial, put the whole history of attacking the president for 4 years on trial, all of those things. And I get why Trump went with the way he went. He was promised that there wasn't 67 votes if he played ball. My view is there never was 67 votes if he had contested it. But that ship has sailed. Ultimately, he has set a record. He's the back-to-back impeachment acquittal king. The only president to be acquitted twice. And if you throw in the Mueller report, really thrice. I mean, he set a record for that. I
genuinely, knowing what I know now, and it's come from a place of nothing. So it's not like I came in with any preconceived notions. To see the impeachment process weaponized the way it was now, it might have been weaponized the first time, and I could accept that because maybe it was weaponized the same way with Bill Clinton, and I just wasn't as sensitive or awake then. But to see the way it's now, it's been turned into a joke now. Like, it's been turned into an actual joke where it's just another tool. It's not just another tool in the toolbox with no sanctity, no respect for what it was. It's interesting to see. And to the comment as to someone asked how you and I met, it's a good segue. I mean, it's segue. We met because back when I just first started exploring all this stuff, I dissected the deposition of AJ, Voldemort, and I think at some point we made a connection on Twitter, and I asked if I could talk to you about everything that you do, and then we started. It's amazing. But
that's right. Yeah, and it was right. It was not long after the Covington case got filed.
Yep.
So it was the combination of those two stories. It's extra. I mean, basically they've burned down every limitation on impeachment that ever existed. And the person doesn't even have to be in office anymore. Why do they even have to be alive anymore? I mean, that's about the only thing they haven't done is impeach a dead person yet.
No, and well, I mean, I guess the issue is always going to be they will never have a similar case because the impeachment would have to be while they were in office, and then they're no longer in office. But like I said,
their view is it doesn't matter. Their view is they could impeach afterwards. Not just that they could hold the trial after office, but they could impeach after office.
I said as a joke, a cynical sort of observational joke on Twitter. It's great. Impeach if you really hate someone enough, impeach on the right before the election, especially if it's a second term, just so you can go after them politically after they're out of office. It's pure weaponizing to the detriment of the essence of the Constitution. And and for anybody who didn't see, I put it up yesterday. The highlight in my summary of the recap of the impeachment. Stacey Plaskett, also an attorney, Joe Neguzzi. They're all attorneys turned politicians. Her response to the montage was to turn it into a racial gender issue, where literally verbatim, and I didn't want to edit anymore. I mean, I wanted to cut the clip down so it was watchable. Literally saying, when they say it, it's insurrection. When we say it, when women or people of color say it, they're fighting for something. And she was proud that other senators fought up with them. She literally said fought up with them, and she was proud of it. Sure, things happened that were violent over the summer, but senators, she brought in the Amish. She brought in senators who fought up with them. It was the most intellectually terrible response that you could have, because in the beginning they're putting Turley in contradiction with his prior statements. Well, by the end they're putting the Democrats in contradiction with their own positions, and not in any subtle way or not any walking back type way. But easy, my recollection is also it wasn't just women and people of color who were using those terms. There were a lot.
They had every single senator saying language of the same language they now said was impermissible and somehow quasi-criminal and impeachable. They had every and that they said language that was frankly much more aggressive followed by much worse violence.
Yep, no question. So he has now been acquitted. The question was this that I had. There is no way that they can go back and redraft articles of impeachment, because now I see Jonathan Turley on Twitter saying, had you listened to me before, you might have gotten a conviction. Had you broken them down into individual charges? Can they remedy any of this?
Not any of this, no. But apparently their position is, if their position is they can also impeach, not just hold a trial after the person has left office, then who knows? I mean, presumably they won't be wasting more time bringing more impeachments, but no limit. They may try some 14th Amendment nonsense.
So what is that? I don't think I know.
The 14th Amendment just said basically allowed for disqualification of office if you had been previously part of a insurrection. It was a civil war meant to give them the right to later on limit Confederate generals from participating in political office. They never enforced it for very long afterwards. Nor does it give Congress the right to determine that. So, and because legally under the impeachment clause, he was just acquitted, there's no basis for it. But who knows? I mean, they're trying to find every crazy thing they can to weaponize. I mean, it's part of what's coming with HR-1 and HR-127.